This week's episode deals with the problems with the pending Orphan Works legislation in the U.S. Congress, which, if passed, would have a global impact. This interview with Brad Holland was recorded on May 12, 2008, New York time. After the interview, I'll fill you in on links you can go to for more information, or you can visit the podcast page at globalcomics.net. This is Tim, and this is Deconstructing Comics. This is Deconstructing Comics, sponsored by ComicsNow.com. Today I'm talking to Brad Holland, who is in New York City right now, and I'm in Tokyo as always. But Brad Holland is a very accomplished illustrator and writer, according to the bio I found for him. I'm unfortunately not terribly familiar with your work, although looking at some of it on your site, the style felt familiar to me. I'm sure I've seen it before.
Well, it's been around.
Yeah. So what would you say is probably your work that has gotten the most kind of play, or would people be most likely to have seen?
Well, it's been seen in a number of places. We probably ought to talk about the issues, not my work. But
okay.
For example, I've done Time covers for covers for Time magazine. I've done. I did paintings of Stevie Ray Vaughan for his first record album for Billy Joel. Mm-hmm. I've done posters. I've done all kinds of paintings.
Okay. Yeah, I just want
all
to
over the place.
Kind of establish who you are.
Sure.
And you're also co-chair of...
Doing this kind of stuff isn't what I do for a living. I mean, I've been painting for years,
mm-hmm.
and getting involved in this stuff has been quite an experience. It's not something that I'm used to doing. It's not something we've ever had to do before. It's something that we've had to take on because of what the United States Congress has decided to do to copyright law.
Right. So, since I had to restart my computer here a minute ago, I don't have all my pages open here. Tell me the name of the organization you're co-chairing.
Well, there are a couple of organizations. The Illustrators Partnership was an attempt to bring a number of visual arts organizations together. It includes the National Cartoonist Society, the Society of Illustrators from New York, from Los Angeles, from San Diego, from San Francisco, Pittsburgh, the Washington, D.C. area, and then also artists such as medical illustrators, aviation artists, architectural illustrators, general science illustrators. It's been an effort to bring all these groups together to try to adapt how our secondary rights are going to survive in the Internet era.
Okay. So this is, like you said, this is not your job. This is just this is mainly a kind of a volunteer thing that you're doing, right?
I wouldn't even call it volunteer. We're more like a neighborhood watch group.
Okay.
For example, I was up all night trying to get 2 paintings done that I need to send to Istanbul for a client there. Mm-hmm. And all night long we were getting phone calls from various parts of the world about this crazy legislation that is going to affect everybody's copyrights from everywhere in the world.
Yeah. Okay, so in case our listeners, our listeners are quite possibly people who are just getting started in doing comics or something, and they may mm-hmm. not be familiar with how the current copyright law works. So
sure.
Could you say a few words about that first?
Yeah, very simply, the United States, in the United States, we have to function within 2 forms of copyright law. There is the international copyright law, which goes back to the 1800s and which was largely the result of a campaign by a number of artists led by Victor Hugo, the novelist and poet, which established international copyright law. This is called the Bern International Copyright Convention, as in Bern, Switzerland. Mm-hmm. The United States copyright law is somewhat anomalous and goes back to the United States Constitution. It's actually written into the Constitution, which goes back, of course, to the 1700s. Mm-hmm. And is slightly different from international copyright law in that it doesn't contain certain moral rights for artists that international law allows. But without going into the details of the differences, roughly within the last 30 years, the United States has more or less come into alignment with international copyright law. And what that does is it protects anything you do as an artist or as a citizen. It protects anything you draw, anything you paint, anything you doodle on the margins, any sketch you send to a client, any drawing that you do in a sketchbook, any family snapshot, any home video, anything you do is protected by copyright without what the copyright law calls any formalities, which means you don't have to do anything to protect your work.
Okay.
You don't have to register it. You don't have to put a copyright notice on it. You don't have to do anything. In a nutshell, it presumes that if somebody finds your work, they may not know who did it, but they know they didn't do it, so it isn't theirs.
Okay. So
that's current copyright law.
Okay.
If you're asking how this law is different, it would be vastly different.
Yeah. So
because it would. Go ahead.
Sorry. First of all, let's explain what an orphan work is, because that's the main thing that this legislation deals with.
Sure. Well, it's what it actually is, and what this bill is, are two different things. A real orphaned work is a picture that, for example, was taken 100 years ago or 75 years ago, and to which no owner can be located. In other words, the person may have died, the estate may have dropped the attempt to maintain copyrights, and if you want to use the picture, if you want to use the story, novel, whatever, and you can't locate the copyright owner, you do have a problem with how you can use that work. Because in theory, someone could come out of the woodwork and say, hey, that's my picture, that's my novel, you had no right to use it. And then, in theory, the user would be liable for infringement penalties. Now, there is in the United States, as there is in most of the world, a provision for fair use that says for scholarship purposes you can use that work. You simply can't use it to you can't use it for commercial purposes. You can't run a picture in an advertising campaign, for example, because you can't find the copyright owner. If you find an old painting that you want to use in an ad and you can't locate the copyright owner, and you can be sure that it's not already in the public domain. For example, Michelangelo's work would, I assume, be in the public domain because he's been dead for several hundred years. Michelangelo does not own the copyright on his work any longer. But if something is in doubt, your best option under current copyright law would be to hire someone new to do the work. And one of the reasons for that is it essentially encourages the useful arts, as they're called, because it gives work to a new artist. So that's one of the reasons that, besides protecting the copyrights of people who have already done work, it does tend to encourage the creation of new work. If anything were available for use at any time, especially in the Internet age, you could simply go online, scarf pictures up off the Internet, and use them for advertising campaigns without ever having to locate the rights holder. All you would have to do if someone came out of the woodwork and said, hey, that's my family snapshot you're using for that beer commercial, you could say, well, I made a really hard effort to find you, but there was no name on the picture, and I didn't know where to start looking, and so I just used the work anyway. Under current law, you can't do that. Under the law that the United States is now considering, clients would be able to do that.
Okay. Now, what prompted this legislation to come up in the first place?
Theoretically, we'd like to know that. What we do know, a couple of things, is that somebody registered, some unidentified person registered the domain name orphanart.com on September 7th, 2002. This was 2.5 years before the Copyright Office began their so-called study of orphan works. So we know that somebody either had a crystal ball or somebody had some insider knowledge that the United States was going to be conducting a study in the subject of orphan works, and that they were going to find some way to commercialize that work once the government decided to conduct the study. That raises a red flag right there. Unless somebody literally, was a fortune teller and understood that not only was the government going to conduct this study in abandoned work, but that they were going to use a study in abandoned work to rewrite United States and therefore international copyright law, then we have to assume that somebody had some kind of inside knowledge and was already anticipating making money off of this. So we don't actually know how it started. We do know that the initial legislative blueprint came from a legal clinic, an intellectual property law clinic in Washington associated with American University. They conducted a forum I think it was on April 11th, 2003, which was just about 6 months after somebody registered a domain name through domains by proxy. Mm-hmm. And it was about 2 years before the Copyright Office announced an Orphan Works study. And basically the legislative blueprint that was drawn up at this law clinic by a college professor and 8 law students has become the genesis of this bill. What they proposed in that, as a result of that law clinic, was formulated into what they call the Glushko-Samuelson Copyright Clearance Initiative. And it, in a nutshell, was a limitation on penalties for infringement, which is at the heart of the current legislation.
Okay. Can you explain a little more, like what the legislation says exactly?
What it says in a nutshell, it's very complicated. It's 20 pages in the House version and 20-some pages in the Senate version, and it's very hard to get through. And the fact that legal scholars are already disagreeing over what it says, says a lot about it. Mm-hmm. In a nutshell, what it means is if you want to paint a picture from now on, you better have a lawyer on retainer to explain the law for you. What it would require is, now first of all, let me explain that because international law does not obligate you to register your work, and because international law forbids countries who abide by international law and who have agreed to international treaties. There are a number of intellectual property treaties that relate to the use of intellectual property between different countries. And those treaties have agreed on certain principles that forbid member countries from creating any kind of obstacle to the full enjoyment of copyright, I think as the law puts it. And what that means is countries cannot create things like registries that would force you to register your work as a means of protecting it. So what the United States has done is, in a kind of a lawyerly workaround, they have created a system in which they won't impose these formalities on you. They will simply penalize your work. Let me put it a different way. They won't force you to register your work, for example, or put copyright notations on it, or put your name on it, or something like that. They won't require you to do that, but they will expose your work to infringement if you don't do it yourself. So it's basically a de facto return to formalities, the kind of thing that existed before the Berne International Copyright Law, and the kind of thing that existed in the United States before the 1976 Copyright Act, which was an attempt to harmonize United States law with international law. Mm-hmm. So what it basically does is it gives what they call a safe harbor to an infringer who claims that the infringer himself has done what the law defines as a reasonably diligent search, or rather what I should say the law doesn't define as a reasonably diligent search, because the Copyright Office study itself says that a reasonably diligent search will be defined by the infringer himself. And then if the user finds out that his work has been infringed, which means he has to be in whatever country the work has been infringed on whatever day it has been infringed and reading whatever publication it has been infringed, or he has to go on whatever website it's been infringed anywhere in the world. But assuming that someone has infringed your work, and assuming that you do find out about it, it would be your obligation to try to track the infringer down. And then if the infringer doesn't give you what you think your work is worth, it will be your obligation to take the infringer to court somewhere in the United States. United States copyright law is a federal law, which means you can't file a lawsuit on a local level. You'd have to go to one of the courts that handles federal law and file a lawsuit. And then you would have to contest the infringer's diligent search. And as I said, the Copyright Office itself says that the the definition of a reasonably diligent search would be defined by the user himself, by the copyright owner if the copyright owner catches the infringer, or failing to agree on whether the user has done a reasonably diligent search, then it would be defined by the courts. So basically, these laws are full of these laws. Basically, won't do you any good unless you find out that you've been infringed and go to court. Yeah. And let me just one thing. The bills are full of things like the court shall decide, the court shall determine, the court shall do this. In the legal action, this shall take place. In the legal action, the infringer is entitled to this, and so on. So what it basically is an attempt to drive ordinary business transactions into the courts, or simple privacy transactions, because the kind of work that you put out on file sharing sites, the kind of pictures you may put on blogs or on internet, anything like that would suddenly be exposed to infringement, and it would be your obligation to find out that your work has been infringed, go to court, and contest the kind of search that the user may have done to use that work.
Yeah, I found a site that was supporting the legislation, publicknowledge.org, and I know, and there are a couple of things that
Sure.
what you were just saying that made a couple of sort of felt like just sort of leaps to me, like that, just assuming that that the person who holds the copyright is going to be able to find out about uses of it easily, and also just like, oh, we'll just set up a court, like it's something
Sure.
that can simply be done, and it's not going to get backlogged, by years worth of cases.
Well, the courts have determined that these bills are full of words like reasonable period of time, reasonable application of the law under reasonable circumstances.
Yeah,
the owner of the work, is a reasonable. But then in the Copyright Office study itself, or in the report itself, it says, well, the use of the term reasonable will be determined ultimately by the courts.
Yeah.
Which means that each of these courts will have to do. Oh, yes, it says on a case-by-case basis. So what that means is you will have to drag infringers into court, and what happens in one court may not coincide with what happens in another court. District courts will have different applications of the law, which won't be determined until these things are taken to the Supreme Court, which will easily be at least 10 years by the time all of these district courts come down with different decisions, different definitions of what reasonable means. For example, the same picture could be declared an orphan in one court case and not an orphan in another court case. It would be your obligation, if it's your painting, your drawing, your comic strip, your family photo, it would be your obligation to drag yourself through these courts to a Supreme Court case, to determine whether some person, did a reasonably diligent search, whatever that means, within a reasonable period of time, and whether he offered you a reasonable compensation for your work and agreed to a reasonable negotiating. It's insane.
Yeah, well, and another sort of leap that I saw in this public knowledge stuff was the assumption that since the user did a reasonable search, there's no reason not to assume that they would be willing to pay if they were found using the work, infringing the copyright, rather
Sure.
than dragging you to court. Well, but if the definition of a reasonable search is so squishy,
Right.
Can't assume anything.
Well, a reasonable fee is equally squishy because, for example, suppose I decide I want to go into the infringing business, and I start going on the internet and start harvesting photos and paintings and drawings and cartoons from various blogs, and I do some sort of blanket search on all this work and determine that I don't know where I found them. I found them in my hard drive someplace. I found them on a website. There was no idea. I couldn't track them down. So I will set a price. I will start selling these things at a fee of like 50 cents per image. Mm-hmm. Now, someone says, "Hey, that's my vacation photo you've got." I say, "Okay, here's your 50 cents." Now you can take me to court, but under this law, I don't have to pay you anything other than what's reasonable for the usage as defined by current market rates. So if I've defined a market rate as 50 cents, all I owe you is 50 cents. So you could spend, $10,000, $20,000 to get a lawyer and drag me into court, and what do I have to do? In the end, I'll give you your 50 cents because that's all the law would require.
Yeah.
The law would require you to prove that your work is worth something more. Mm-hmm. And if it's, for example, a sketch that you did in a sketchbook, if it's a comic strip that you submitted to somebody and they didn't use it, and you want to submit it to somebody else, but I found it in the meantime and decided to use it, well, you've got no commercial value attached to that thing, so we might even have to split the difference between your value, which in the marketplace so far is zero, and my value of 50 cents. This is preposterous because you might be able to sell that cartoon the next day for $10,000 for an advertising campaign.
Yeah. So, if this legislation went through, then any artwork, any comic, or even any, as you said, the family photo that you might have put on your website or on MySpace or whatever would be
Sure.
fair game then.
Yes.
And what if I'm a writer? How would it affect? Like if I've written something that I've put on my website, for example.
Well, writers are just beginning to get involved in this because they're just beginning to realize how this would harm them. Illustrators really were the first to catch this. Mm-hmm. And we've been writing about this for several years. I wrote the first article about this back in 2002 when the people who were trying to promote this bill, largely a number of legal scholars, were taking certain cases to the United States Supreme Court trying to have current copyright law declared unconstitutional. And they failed in the Supreme Court, so they have decided to approach this through the legislative branch. And if they approached it straightforwardly and said, well, we want to undo existing copyright law, they would get nowhere. So they've gone at it by saying, we just want to free up some of these old pictures. You find a picture of Grandma in the attic, and you can't take Grandma down to Walmart right now because Walmart won't duplicate it because they might infringe somebody's copyright. Well, under this law, they really haven't solved that problem because under this law, before you take the picture of Grandma to Walmart, you'll have to register it with a private registry someplace, or Grandma might be duplicated at Walmart and sold to one of these harvesting companies to be used as an ad someplace. So you better be sure if you want to duplicate any future pictures of Grandma, you better make sure you register them first.
Okay, but as far as writing, how would a writer be affected?
Well, writers would be less affected, one presumes. First of all, because not many novels are going to be used in advertising campaigns or something like that. That's one of them. First of all, the issue of art has a much broader and much more profligate usage than say a novel or a short story or something like that. Mm-hmm. But in theory, yes, if someone wanted to republish a novel and they claimed they couldn't find the copyright owner, or a script that you sent to a motion picture company, and the company could say, well, the name fell off it. We didn't know how to locate the writer, but it seemed like a good idea. It's been laying around here for a couple of years. We made a diligent search to find who sent it in, but we can't locate it. So we've made this blockbuster movie, and you've shown up, and we don't pay a lot for these orphan screenplays that we find laying around. Now, how that would work, I'm not going to try to get into that because we haven't spent a lot of time looking into how Hollywood conducts business over screenplays, so I will leave that to others to try to define. But this could essentially apply to music, could apply to any creative art.
Mm-hmm. Yeah, well, and all that kind of stuff is on the internet. Now, would if I were, say, a visual artist and I didn't have anything on the internet, could I? And say if I didn't have anything published, would there still be cause for concern?
Well, I don't assume that people are going to be coming into your house and stealing your property.
Yeah.
I mean, if that happens, that happens. But that's breaking and entering. That's plain old property theft. Yeah. So no, I don't assume that there's some way that your work is going to migrate out of your home and into the internet unless somebody puts it there. Mm-hmm. But for example, you're an artist. You go out and you do a sketchbook. You riding on the subway, you leave your sketchbook on the subway. Well, there it is. Under current copyright law, nobody can do anything with it. Mm. Under this law, if your name isn't in it, or somebody has ripped your name off, or you haven't signed every individual page, or somebody hasn't taken your name off the page, or something like that, yeah, then the work is theoretically an orphan again. Mm-hmm. But I certainly don't assume that, as I said, that the government is going to condone breaking and entering and robbing people's pictures off their wall and entering them. That's a whole different level of problem.
But anything you might have done that has somehow gotten out into the public sphere.
Yeah, anything that is publicly exposed. For example, artists 20 years ago were still sending portfolios around in order to get work. If you're a young artist and you want to get published, you all know that you have to do work and you have to take it around and get it seen. You can't just go out and say, hey, I want to be an artist, call me and I'll show you what I can do. And call me, pay me, and I'll show you what I can do. Every artist has to go out and do lots of work that for nothing that they take around as samples. That's the way you used to do work. Now you have to put that stuff on the internet to make it available. It's kind of like a shop window. You have to put merchandise in the window so people know what's inside the store. This law is essentially like something that says, well, if somebody knocks a hole in the window, any merchandise in the store is fair game to anybody who takes it off and sells it on the street corner, because I can say, well, I didn't know what was in the store window, so I just bought it from this guy on the corner, and yeah, maybe it was taken from the store with a broken window, but it's not my responsibility because I bought it from the guy in the corner.
Now, if assume a different scenario, say that I'm in France, say that I'm French, and I've put up a website on a server in France, and I've got some art up there. It's still could just as easily get mined by somebody, and they say they couldn't identify me, and they start using it.
Sure.
And then what might happen at that point in terms of the legal aspect?
This thing is a copyright virus. There's no way to tell where a picture has come from unless that picture is marked or identified in some other way on the work itself. For example, you could take Henri Cartier-Bresson, who was French, and who just died a few years ago. Under international copyright law in the EU and in the United States, his work would be protected for another 60-some years. Under this law, it could be royalty-free by the end of this year in the United States, protected by a law that's unique to the United States. And it would be up to the estate of Cartier-Bresson to come to the United States and file lawsuits against those infringers, or for other countries to start retaliating against the United States in other areas by filing complaints with the World Trade Organization or something like that.
Mm-hmm.
But no, everybody who creates any kind of thing anywhere in the world ought to be worried about this, because it really is an attempt by a number of legal scholars, supported, I should add, by several large corporations. Google, for example, has already said they plan to use millions of these images, because Google and companies like Getty and Corbis, who are essentially opposed to the bill in theory, but under this law would be able to harvest unidentified work, create what are called derivatives of the work, and then copyright the derivatives of the work. For example, I find a picture that you've done, and I crop it, and maybe I change the color a little bit, or I Photoshop a little, something in here. Now I can copyright that picture and register it, and then I could hire one of these companies like PicScout that will scout the internet. Some very expensive technology that will scout the internet for infringements. And so if I'm Bill Gates and I own Corbis, I should be able to track infringements down by using this technology and protecting the copyrights. But I could also harvest other people's work, make what are called derivatives from that work, and then legally copyright and register the derivatives in my own name, so that the infringing work, the work that has been infringed from somebody else's work, would be the registered work, and the original work may still not be registered anywhere in the world. In other words, you would in the future be competing with these companies that have made derivatives of your own work.
Now, is there what would be a better way to accomplish the legitimate goal of addressing the Orphan Works situation? Sure. I mean, could this legislation be fixed somehow?
It should be fixed. We have made the proposal before the Senate that the Orphan Works bill should affect only orphaned works. And this is why companies like Public Knowledge, which you said support the bill, they have actually promoted the bill. They're one of the organizations that's been responsible for promoting this legislation. So they're only backing what they've been lobbying for all along. This bill should be limited to true orphan works. It can be done. Other countries are trying to find a way to do it. Canada already has an Orphan Works board that allows you to go to Canada and claim that you want to use orphan work. You declare what you want to use it for. You give them an example of the work. The Canadian Review Board, the Orphan Works Review Board, whatever it's called, goes through the effort of either trying to locate the author, or if they fail to, they give a license that is good for that particular use to the person who wants to use it. It's a very rational procedure for doing this.
So it's
fair use. Fair use already covers a good number of usages. For example, in the legislative history of the 1976 United States Copyright Act, in the legislative history of that act, they make it quite clear that the copyright lifetime plus 50 years, as it was at the time, now it's lifetime plus 70, that the current copyright bill will not impede scholars' will not keep scholars from using the work for scholarly purposes. It only prohibits the commercialization of that use. Now, libraries and museums want an expanded usage in order to commercialize orphaned work for usage on bags and keychains or whatever. But for the kind of things they might sell in gift shops and so on. If government wants to allow that kind of usage, one presumes they could limit the use of orphaned work to that particular category.
So it sounds like the Canadian approach is assuming by default that something is copyrighted rather than sort of assuming by default that it's orphaned.
Yes.
Yeah.
That's the best expression. That you've done it right there. The United States government will essentially assume that it's orphaned until you prove otherwise.
Mm-hmm.
And in Canada, they follow the logical precept that your work is yours until somebody else proves that either they have a compelling use to use it, in which case they're granted a specific license for that specific use. That should be good enough for any organization in the United States.
So both houses of Congress have a version of this in front of them. Has there been any vote scheduled?
We get very short notice as to what they're going to do. The House Judiciary Committee marked up their version of the bill a couple of weeks ago. The Senate was supposed to mark up their version last Thursday. We've been told that it was rescheduled until this Thursday. After that, they decide, it's their schedule. They can decide whether it goes for a vote right away. We have to find out what the procedure is almost on a day-by-day basis. Now, we set up a website. The Illustrators Partnership set up a website less than a week ago to start sending letters to members of Congress. And within the last 5 days, we've already had over 51,000 letters go out from that website, from illustrators, photographers, designers, and increasingly from ordinary citizens who are suddenly, getting the idea that their work, in fact, their privacy itself, could be endangered by this blunderbuss attack on copyright law. Mm-hmm. And we do have a number of sample letters in this. If you're overseas, there's a specific website that you can go to, that you can link to from the letter writing site, that will show you which agencies of the United States government to write these letters to. And this can be done with a push button. All you have to do is essentially endorse the letter or add your own comments to it, and then type in your country, zip code, whatever, and it will automatically go to the right source. So you can do this in just a matter of minutes. It's a very simple process. It is done in league with the United States Congress, so this is a system that has been vetted by the Congress specifically for this purpose. And it's being used. We have the logos of at least 11 different organizations on it that are backing it so far. Mm-hmm. As I said, photographers, illustrators. We got news from Istanbul today that a group of writers over there is getting concerned. We have news from Boston that a group of writers is involving themselves. So we're hoping to generate enough opposition to this bill in a very short period of time to at least stall it in the House and try to redeploy it so that it can be used to solve the real problem of orphan works, instead of creating millions of orphans out of existing copyrighted works.
Yeah, I went to the site yesterday and sent a message to my congressman in Iowa.
Great.
So
Great.
Yeah, it's really easy to do. Okay, well, thanks.
Well, we're going to be putting up a new letter shortly to try to get Congress to endorse our markup amendments as soon as we can get them before the Senate. That's a problem I won't involve your audience in. But assuming we can get these markup comments to the Senate in time for Thursday, we would like massive support for people saying, please make this bill limited to real orphan work only, and not to the work of our artists who are living, working, and managing their copyrights. But think of it this way. This law, which was originally intended to be an orphan works bill, when the chairman of the House Judiciary Committee opened hearings this year on March 13th, he began, I can almost quote him exactly, he said, the word orphan is a misnomer in this case. This really isn't about orphan works, it's about copyright owners who are hard to locate. He said, so what we're talking about is a market failure. But he said, for convenience sake, we'll continue to talk about them as if they're orphan works. Well, boil this down. I'm an artist. I'm working. I manage my copyrights. I can be found. My clients find me all the time. They find me from countries as far away as Istanbul, from Brazil, from Japan. I'm found by clients all over the world. But that doesn't mean that anybody can find me at any particular time. What this law does is says that any one person who can't find me would become the measure of whether I can be located or not. In other words, if 100 clients can find me, but one knucklehead somewhere can't, that one knucklehead has a free ride to use my work, while anybody who can find me has to negotiate a reasonable fee with me under voluntary transactions, not after the fact.
Yeah.
So this one incompetent person, or this one person who simply isn't versed in how to go about finding an artist, could, even if he doesn't do a diligent search, could use my work, and it would be my obligation to find out about it, haul him into court, prove that he didn't do a diligent search, and then what? Maybe find out that he doesn't have enough money to pay even if I do win an infringement lawsuit against him? Yeah. This is simply no way to conduct, this is no law to conduct the affairs of protecting private property.
Yeah. Okay, well, thanks so much for coming on the podcast. We'll kind of try to keep up to date on the situation and mention.
Please
the
do.
podcast
Send your listeners to our site, and if they agree with this, then please have them write Congress.
Okay.
Thank you again very much, Tim.
Sure.
Appreciate it. Okay. Bye.
Bye. Thanks again to Brad Holland for being on the show. The website to contact your congressman about this bill is capwiz, capwiz.com/illustratorspartnership/home. That URL and several others about Orphan Works, the Illustrators Partnership, and about Brad Holland's work can be found on the podcast page at globalcomics.net. Remember that this is the month when Alex Robinson's Too Cool to Be Forgotten from Top Shelf is being solicited by Diamond, as well as The Martian Confederacy, written by Jason McNamara, drawn by Paige Braddock, and colored by Brian Miller's Hi-Fi Studios. All these creators have been on Deconstructing Comics in the past few months, so go back in the feed or on our website at globalcomics.net and listen to those shows if you haven't yet, and then visit comicsnow.com for big discounts on both. Comics Now provides many of the comics we review on this show, as well as Eric's newsletter, which you can read on our site, globalcomics.net. Our theme song is performed by Firewater. Let us give you some feedback on your comic. Send it to us at podcast@globalcomics.net, and we'll review it on the show. Also, if you'd like to send us a donation to help keep the show going, use the PayPal link on the podcast page at globalcomics.net. Next week, Matt Sility will be back to talk about the graphic novel workshop he recently taught, as well as his Eisner nomination and his next project. Till then, thanks for listening. This is Tim. See you next week on Deconstructing Comics.